In this episode of CALS Chai Chats, we delve into the role of the judiciary in the Philippines, an archipelago of over 7,000 islands with a diverse population. And as in many countries in the region, a country confronting evolving and increasingly complex societal challenges. In the context of the Philippines, these include the disparity between different social classes, complex peace processes and local autonomy issues, and fundamental rights concerns in a Catholic majority nation.
Today, we have the honor of discussing these important topics with the Justice of the Supreme Court of the Philippines, Justice Amy Lazaro-Javier. She is currently one of the two female associate justices of the Supreme Court. Justice Javier has had an extensive legal career. Prior to her judicial appointment, she was a trial attorney and an assistant solicitor general at the Office of the Solicitor General. She then served as an associate justice of the Court of Appeals from 2007 before being appointed to the Supreme Court in 2019.
All right, Justice Javier, welcome to CALS Chai Chats, and thank you for joining us in this episode of our series on judging and social cohesion in Asia.
Thank you for inviting me.
So to start the conversation, Justice Javier, I was wondering whether you could offer some reflections on your experience as being a woman on the Supreme Court of the Philippines. I know you've been on various committees of the court. Would you like to just share some of your experiences as a woman judge?
Yes. First of all, I would like, thank you for that question, Mario. First of all, I would like to discuss the ratio of women and men in the judiciary as a whole. So far, we have this development, a big leap, actually, a quantum leap on the ratio of men and women in the judiciary. As of our last count, the women judges in the trial courts, they have already exceeded the 50%, yes, 50%. So they now comprise 58% of the appointments in the trial court. And
Wow.
yes, and the women passers of the bar, their number also has broken that 50% domain. So around 57% or 58% of women, more women are now bar passers. Okay, and I suppose that more women, from my experience, more women are now taking up law in the Philippines. All right. And in the appellate court, that is also being observed now. I think we have not really 50-50, but we're close to that already. All right. But that kind of ratio has yet to trickle up to the Supreme Court. As you know, out of the 15 justices of the Supreme Court, only Justice Monette Singh and I are women. We are called the twin female voices of the court. So why is that so? First of all, women, especially the lawyers, they have this self-imposed limitation. They are of the belief, of the general belief that as you go up the ladder, okay, you are somehow diminishing your quality time with your family. So because the women in the Philippines, their top priority is their family. They'd rather just stay, most of them in the trial court or some of them in the appellate court, but no longer in the Supreme Court, among others because of that self-imposed limitation. But I am so lucky that I have a husband who is very supportive of me, and who's a progressive man at that. And I attribute my achievements to him. Were he not my partner, if he were not my partner, I don't think I would manage to my career. And I am also very, very lucky that the men around me are progressive men. Like my former bosses, they would allow me to bring my children to my office, okay, and go out from time to time to fetch them, all right, and to attend some of the best parent teachers conferences. So I try to strike a balance, but striking a balance alone is not possible.
Mm.
People around us to also support us to keep that kind of balance. So
Mm.
I would like to say that, it is my hope and wish that uh, the women in the judiciary and even outside judiciary in the Supreme Court will also be inspired to do their best, aim high, and strike a balance between their career and their family.
I'm just going to ask a quick follow-up question to that. And I was wondering, as being one of the two women on the Supreme Court, whether you feel an obligation, therefore, to advance issues of women's rights and gender equality, or do you feel that the court as a whole has a similar obligation to do that?
Well, I think I have a personal and moral obligation to advance gender sensitivity and equality and protection for women. It is my personal conviction, but it also blends with the conviction of the entire court. Because I would say that even though we are outnumbered, only 2 out of 15, we have never been muffled or silenced with our opinions. We have always been respected, and there are times that we can sway, we are able to sway the opinion of the entire court just because we speak up, and the people around us, all 13 men, are progressive minded, and they support us and respect us. And I would say that if we now examine the decisions of the Supreme Court decisions are gender sensitive, gender neutral, and even in our own language, we are so. In fact, during this, it is under this court that we came up with our very first organic uh, regulation or circular. uh, we are requiring our judges, the members of the legal profession, to use language sensitive, gender sensitive language, fair language, and to observe court etiquette, especially dealing with children and women. And we also observe these rules in our own decisions. In fact, we correct each other, we check each other whenever we see a line or two which we think does not conform with the use of gender fair language. So in all opinions, in all decisions, whether they involve gender, women, or children, we are on the same page with every other member of the court. And we are so lucky and blessed with that.
I'd like to follow up, if I may, Justice Javier, on something that you alluded to earlier, which I found quite interesting. There seems to be this environment, perhaps entrenched social practices or cultural practices that seem to impede women. But in a way, you also mentioned that it's important to have that environment or the structural support for women to actually succeed in their careers, whether as a judge or in other professions that they might pursue. So I want to extend that conversation a bit, Justice Javier, maybe talk about some of the most pressing social issues in the Philippines that you've observed in your experience, and how or whether such issues have come before the courts?
Yes, thank you, Diane. We have complex socio-economic issues, mainly because, we come from, we're not exact, how do you call that? We come from the global south.
Mm.
Know what I mean? All right. So our problems are complicated socio-economic problems. The first one is, of course, poverty. But poverty is not an isolated problem. It is interconnected with lack of education, with underemployment, with unemployment, and many other economic factors. These affect also the access to justice by our people who cannot afford to be represented by their private counsel. Of course, the government provides them free legal aid or free access, like the public assistance office. But we have limited number of lawyers, and we cannot, that office alone cannot answer for litigants who, because of lack of funds, cannot get themselves efficiently represented in court. So,
Right.
of course, we realize that before the court, because our court is not just a passive court. We don't just receive cases and resolve the cases. The court now in the Philippines goes out of its way to find out how to empower people and what impedes the administration of justice insofar as the poor segment of society is concerned. So we have created several committees within the court, like the Committee on Free Legal Aid, so that we could empower and give assistance and support to the Integrated Bar of the Philippines and other organizations that provide free legal aid to poor litigants. So we could also complement or supplement the grants coming from the government itself. And then there are cases where, we also allow the litigants themselves to just represent themselves, because we know that these litigants cannot afford to be represented by counsel. Okay, there are also cases that we liberalize the rules so that we can, yes, we can dispense justice to the poorest of the poor. So
It's very interesting.
the court now is more involved. We have this justice on wheels. So where those litigants or witnesses who cannot go to the court itself because of the distance or lack of means to transport themselves, we have wheels of justice to go there. And the wheels of justice, the bus itself is equipped with technical, gadgets, so that we can get these witnesses connected to the court, and they can also testify online using satellite. That's what we do so that we can bring justice to the poorest of the poor and to the undeserved, the most undeserved.
That's really interesting, Justice Javier. Wheels of justice. I like that. So it's a bus that goes around the country.
Goes around the farthest, the remotest part of the country. That is where these buses go. Okay, and also we go to witnesses who, not only because they are in the poor segment of society, but because they are scared for their life. They cannot, come face to face with the accused.
Right.
We go to them through our wheels of justice. And we allow online testimony, subject to rules, of course.
Hmm. So this is, again, I find this really fascinating, access to justice issues for the poor. And clearly, the court is, as you said, not just a passive court. It works actively to empower people, to empower litigants. So perhaps we could talk about the role of judges and courts then. This is a good seg into that conversation because, conventionally, the role of judges is often understood as revolving around, the interpretation and application of the law. Judges sit in the courts, people come to them where cases arise, and the wheels of justice run within the four walls of the court. But this is something different that you've described here. Is it always straightforward, Justice Javier, that this role of judges is often understood as revolving around interpreting and applying the law?
Yes, we are jurists, but we are also human beings. They say that the law may be harsh, but that is the law. But you can never be wrong with equity. When what is legal becomes inequitable, then that is not justice. We always are guided by the principle that, if the letter of the law is clear, then apply the law. But if the spirit is not within the letter, then the letter is not the law. The spirit should govern rather than the letter alone. And our law, our courts are not just courts of law, but we are also courts of equity. So there have been times when we abandon the letter of the law because it is outside the spirit of the law. The very reason why that law was promulgated in the first place. For example, although the letter of the law is clear that the forest land cannot be appropriated without a government permit. When an IP, a member of the indigenous people in the Philippines who does not have a high level of education, cut a tree to build a communal community for all the community within, for all the members of the community.
What would have been the consequences for that?
Okay, if we apply the letter of the law, which the lower court did and the appellate court did, then we will send this person in prison just because, according to their tradition, if the tree is found within their domain, then they can cut it not for their personal use, but for the use of the community. So went up to the Supreme Court. We applied equity. We applied the fact that this is an IP person, and as an IP person, he grew up not in the mainstream. He did not even know about the law. He did not know that there are limitations in cutting down trees, even though he will use it for the communal toilet. But we have to realize that he acted in good faith. He acted in good faith. His own level of civilization did not allow him to imbibe or even know the existence of these laws. So in that case, we acquitted that person and we applied equity, which is not exactly what the law says. I think we did a good thing there, applying equity over the letter of the law.
That's really very interesting. I wonder whether I could just push you a little further and ask you whether you can share with us one or two other examples where issues of social cohesion or social justice has reached the court, and the tools that the Supreme Court is used to sort of navigate and balance the different interests.
Yes, I could name three, not just two, three. One is a, a case of divorce. As you know, in the Philippines, we don't have divorce because we are traditionally a Catholic country. And for Catholics like us, and because of the influence of the Catholic Church to our people, I don't think we can see divorce even in 100 years. Okay, but we do have the annulment of marriage. And we do have also a recognition of divorce that was obtained abroad. Our position is that if a if a foreigner whose country allows divorce divorces a Filipino, it is unfair for that person, the foreigner, to have his marriage dissolved and have another chance to get married again, while our citizen remains married to that foreigner and is precluded from getting married again. So in one case, we recognize that divorce is also it is also it should be recognized in the Philippines, not only with respect to the foreigner, but also with respect to our own citizen. Okay, and in another case, although a foreigner is married to a Filipino, if it is the foreigner who will divorce the Filipino, it is recognized. But if it is the Filipino that will divorce the foreigner, it will not be recognized. That is unfair. So we also cured that. Okay, so if a Filipino is married to a foreigner and then divorce is obtained even by the Filipino himself or herself, okay, that should be recognized as well in the Philippines. Another is we used to apply the presumption that when it comes to illegitimate children, okay, the family of the parents, especially the father, who has not married the mother of the child, would also spurn the child because they don't want their family name to be stained, so that such that the interpretation has been this child, illegitimate at that, cannot be an heir to the estate of his or her ascendants, whether by the mother or by the father. But that used to be called the Iron Curtain Rule, and that governed us for more than 50 years. Okay, but just in 2021, the present court, okay, abandoned the Iron Curtain Rule, and we also abandoned the presumption that simply because a child is illegitimate, that the child is already unloved, okay, or not loved by the relatives of his or her parents. So we gave that child, we recognize the right of the child to succeed the estate of the ascendants of his father or his mother by representing his or her deceased mother or father. That's another is, you know, although we do have annulment of marriage, which is not divorce, okay, the grant of annulment of marriage by the Supreme Court, at least for 20 years or more, okay, before 2021, was really very low, very low. Maybe because of, you know, we're Catholic, and the belief had been that, you know, whatever God puts together, joins together, no man should, you know, put asunder. Is that it? All right. No man can separate. But we also progressed. on that score. In 2021, we had Tan Andal versus Tan Andal, where the Supreme Court abandoned the concept of psychological incapacity as a medical as a medical concept. Instead, it is a legal concept now. And we also abandoned the need for a medical expert. Although the advice of a medical expert is welcome, it is not a requirement. So we resolve the case holistically. Okay? And we also abandoned the rule that whenever the respondent spouse does not come to get himself or herself examined, then there can be no psychological incapacity to speak of because he was not personally examined. We also abandoned that. We now accepted the testimony of the petitioner, okay, as the best evidence, and then also the other witnesses that the petitioner may also bring in. So those are the three cases where the court has shifted.
Those are some really interesting examples. Again, thank you, Justice Javier, for sharing this with us. You talked about, for instance, the annulment of marriage, the Iron Curtain Rule as an example. I mean, I can imagine these decisions or the approaches taken by the court going against entrenched social practices and beliefs, especially in a majority Catholic society. So how does public opinion figure into the court's decision-making process? And in your opinion, how is the Supreme Court currently perceived by the public?
Well, to your first question, we're not, the Supreme Court and the judiciary is the third branch of government. And our independence is sacred in our Constitution and in our laws and in the heart of every Filipino. So the Constitution does not allow, in fact, it prohibits the members of the judiciary to be affected by public opinion. So we have the sub judice rule that and it's in our code of ethics and in the code of ethics of every lawyer and every judge, that the litigants are not allowed to speak about the case anywhere, in any forum, lest the judge be affected or swayed by that opinion. So we have had cases where we cited in contempt those that have violated this rule. We are jurists, but we are also human beings. And so we are avoiding any occasion or temptation in which we may be swayed by any outside factor other than the law itself and the evidence. So that's how we do it. Public opinion, of course, we also read the papers. But we always abide by the law, and we are always abiding by the evidence on record. And with respect to the standing of the court, historically, the court was a virtual unknown to so many people since its founding in 1901. Because as I have told you earlier, and which is also, I think, applicable to every country in the world, the members of the judiciary are unknown to people. We don't publicly present ourselves. We don't attend shows. We don't attend. We don't go to we don't attend TV shows, or we don't speak on radio. Okay, we're not on social media. Okay, but as I've told you earlier, this court is a different court now. We realize that we have to be known by the people. The people should know what we're doing, and how we can also uplift them, how their problems can be solved by the court. So we are bringing the court closer to the people, and maybe because of that, the people now have more awareness about our existence, what we're doing for them. And so for the first time last year, the approval rating of the Chief Justice has really risen remarkably. In fact, the Supreme Court is number one. The Chief Justice and the Supreme Court have been rated number one among the business group. They're so happy how we resolve the cases, the business and commercial cases. And just recently also, through a national forum, the Supreme Court has been rated as one of the top 5 employers in the Philippines. So that's how we are now perceived by the people. I think they have more awareness of who we are and what we're doing for our country.
I just want to move the conversation in a different direction now, and to ask you about the role that international law and comparative law play in your decisions. Does the Supreme Court at all look at international law, look at comparative law, whether it's from the Asian region or from elsewhere, when you
Yes.
decide cases?
Yes, definitely. The Constitution itself provides that the general principles of international law form part of the law of the land. So we apply international law in our cases. Okay, and we are bound by them, because no less than the Constitution binds us to these international laws. But with respect to comparative law, the laws of our countries may have a persuasive effect on us, especially in cases that are novel and have not yet been encountered before by the court. So we don't have any existing jurisprudence on the same, or perhaps any similar law or applicable law. But so we can look on the laws of other countries to guide us, but never to bind us. So that's the difference.
Maybe a sort of related question is on, you said that the court is now going out and trying to empower the people. I wonder, in terms of the litigation model you use, do you see sort of constitutional adjudication and litigation as being more of a partnership and not an adversarial contest between the litigant and somebody else?
Yes, we're actually, we have rules where the parties they're not just encouraged, but required to go through mediation. Okay, so we involve mediators to get the parties together and agree to settle their differences out of court. Okay, so, and we're very successful on that, especially when it comes to small claims. Okay, but when the parties refuse to do so, we go through the court itself, and within the court there is another level of mediation. Okay, another level of mediation. So And it is also very successful. You know, the mediation procedure has already reached the point that it has been an integral part of dispensing justice. I think the best justice is when the litigants themselves settle their differences. Everybody wins there. Okay. Now, with respect to the non-litigious, is it possible for a case to be non-litigious? Of course, we have non-litigious cases, like, for example, in the special proceedings, there are adoption cases, guardianship proceedings, settlement of estates. Most of these special proceedings, they're non-litigious. Okay, so we don't have adverse parties most of the time. But with respect to those that are litigious in character, we want the parties to be at the very beginning transparent, in the sense that in their petition or complaint, they have already to attach all their evidence, so that whatever evidence is not attached will no longer be considered during the trial. And for the parties, the defendants, for example, to also be equally transparent and attach all the defenses, all the evidence to his or her answer, such that when the judge may, based on the pleadings, and if the judge sees that there is nothing more to resolve that has not been presented, that needs to be needs further presentation of evidence, then the judge can already render a judgment based on the pleadings themselves. So in that sense, I would say that we have instilled in the hearts of every litigant, in the minds and hearts of the litigants, that, you know, this is not a hide and seek game. From the very beginning, you have to be transparent. And it's good if you will just make admissions that are truthful, because otherwise you will be liable, and your lawyer who is assisting you will also be liable.
So perhaps we can move from those general rules on processes to talk about more specific cases. Now, the Philippines is a diverse nation, home to a variety of religions, ethnicities, and cultures, despite being a majority Catholic country. Now, one implication that we've seen is the significance of local autonomy and decentralization, which has also implicated peace process efforts in the Philippines. And the Supreme Court has played an important role in this. For example, it declared unconstitutional a proposed deal between the Moro Islamic Liberation Front and the government in 2008. So with the recent formation of the Bangsamoro Autonomous Region, for instance, constitutional issues on social cohesion may continue to arise. So in your opinion, Justice Javier, what is the role of the judiciary in these cases of local autonomy and self-governance?
Yes. Local autonomy and self-governance are mandates of the Constitution. And in many of the cases of the Supreme Court, we have always respected the concept of local autonomy and self-governance. But we also consider and apply equally the fact that despite local autonomy, no one is a different state from the Republic of the Philippines. Every local unit is part and parcel of the whole Republic of the Philippines. And so that case you mentioned, okay, about the North Cotabato and versus Liberation Front, there the what MOA, okay, how do you call that? The MOA of these two groups, the Republic of the Philippines and the Moro Liberation Front. They call the Memorandum of Agreement only a MOA AD. It is like an innocuously titled or captioned document. But if you study the provisions very, very carefully, you will find out, and the Supreme Court found this out, that what was being meant was not only to empower the self-governance ability and autonomy of the MNLF, but to separate it as an independent state from the Republic of the Philippines.
Ah.
The Supreme Court did not allow. And so that agreement.
So as they say, the devil is in the details.
Yes. Rightly so. Rightly so. So while the Supreme Court balances the different commands of the Constitution, okay, while we do respect local autonomy and self-governments, okay, we have to remain the last arbiter on the validity or constitutionality of every act of government. And so we adhere to being the third branch of government that exercises the power of judicial review. So that is what in this case.
So in a way, perhaps you may correct me if I'm wrong. This is the court sticking by the dictates of the Constitution, as opposed to thinking about broader sort of social relations issues. I mean, I can imagine this being a really divisive issue in the society, right? You're talking about carving out a piece of land, as you said, to be separate and independent from the rest of the republic.
Yes, yes. They were given the attributes. They have armed forces of themselves. Okay, they have 3 branches of government as well, and the Philippine government, the Republic of the Philippines, cannot impose on them any law or regulation. They have their own lawmaking, power. So it's really, getting them ready to become an independent state.
Yes. Maybe a quick sort of concluding question. I get the impression that judges these days are talking to each other much more than they did previously, in different countries through judicial conferences and so on. Do you think that's happening with the Philippine Supreme Court? And do you find these interactions and conversations with other judges to be useful?
Very useful. In fact, it is during this court. The court is very much interested in sharing and learning good practices from our sisters and brothers abroad. And we're so involved, like in the Hague Convention on the cross-border disputes, cross-border abduction cases. We're very much involved in that. We're involved in the CALESA. If you know that, the CALESA, the court, many of us are now in Malaga, Spain, to attend it. And then we have also the Philippine Women Judges Association and International Association of Women Judges. We're very visible in that forum. We also have the UN on Human Rights, and many other forums that we attend, because we want to share whatever their good practices are, which we can apply to our country.
Well, thank you, Justice Javier, for your insights from the general to the specific. It's been a really fascinating conversation and fascinating for us to learn about the Philippines, social cohesion issues in the Philippines, and the workings of the judiciary from a judge's perspective. So we thank you for your time, and hopefully we can welcome you to Singapore at some point.
Yes, yes. Singapore is one of our favorite destinations.
So we must get you here then.
Yes, yes.
Thank you, Justice Javier. It's been a pleasure.
Thank you very much.